Hello and welcome to this updated training on Temporary Protected Status, or TPS, for Haitians. My name is Tamara Bloom, one of the attorneys with CUNY Citizenship Now. Thank you so much for volunteering. Our next free Haitian TPS application assistance event will be held on Saturday, June 11th, 2011. The doors will open from 10 a.m. to 3 p.m. and only the first 400 attendees will be admitted. The event will be held at PS 181, located at 1023 New York Avenue, Brooklyn, New York, 11203, between Tilden and Snyder Avenues. For more information on how to volunteer with us at this event, or how to come and have a lawyer or immigration professional assist you with your application, please go to our website at www.cuny.edu/citizenshipnow. The following webinar was originally presented shortly after TPS status was designated for Haiti in January 2010. On May 19, 2011, the Secretary of Homeland Security, Janet Napolitano, announced the redesignation of Haiti for TPS and extended the current designation for 18 months through January 22, 2013. The Haitian nationals who were approved for temporary protected status after the earthquake must now re-register if they wish to continue to reside and work in the United States. Otherwise, their status will expire on July 22, 2011. The last day to re-register is August 22, 2011. They will need to submit a copy of the approval letter, work permit front and back, as well as 2 photographs along with the application. There are also fees associated with the re-registration that are different from the initial application fees. They vary depending on the applicant as shown. Applicants will use USCIS Form I-821 to re-register. Applicants who are re-registering should be sure to check Letter B of Part 1. Secretary Napolitano has also announced that Haitians who have not yet obtained TPS, but who were physically present in the United States on January 12, 2011, and have been continuously present since that date, may now apply. The process for these applicants will be the same as described in the webinar that follows. However, please keep in mind that the cutoff date mentioned in this presentation has now been extended to January 12, 2011. There are different fees associated with initial applications for TPS. Again, they vary depending on the applicant as shown. Finally, anyone who has ever been arrested or charged with a crime must include certificates of disposition with their application. This includes Haitians wishing to re-register who have been arrested or convicted of a crime since they initially received TPS. Sometimes this might affect an applicant's ability to re-register. Please speak to an immigration expert if this applies to you or to someone you are assisting.
We thank our co-sponsors, the CUNY School of Professional Studies, the Legal Aid Society, the Mayor's Office of Immigrant Affairs, and the New York Immigration Coalition for making this event possible. Now let me introduce today's webinar host, Alan Wernick. Alan is the CUNY Citizenship Now Director. He is also a very well-known immigration attorney, columnist with the Daily News, and professor of law at Baruch College. Hi Alan, how are you?
I'm fine. Thank you so much, Sophia. And thank you all for joining us. We have a terrific program today. It's lengthy. It will go on until 5 o'clock, and we have a lot to cover. So I'm going to keep the introduction short and the overview and welcome short. But before we get started, I want to introduce a special guest, and that's Senior Vice Chancellor for University Relations and Secretary of the Board of Trustees, Jay Hershenson. Vice Chancellor Hershenson has been the vision and the power behind Citizenship Now since its very beginning, and it's thanks to his leadership and support within the university that we have the resources to be able to do an event like this today. So, Senior Vice Chancellor, would you like to say a few words?
Thank you very much, Professor Alan Wernick, and everyone who is involved in this webinar. This really is a tremendous cooperation and collaboration between the Mayor's Office of Immigrant Affairs, the Legal Aid Society, CUNY Citizenship Now, the School of Professional Studies, so many organizations, sanctuaries for families, many individuals, Jojo Annabelle from the Legal Aid Society, Julie Dinerstein, from Sanctuaries for Families. It's impossible to name every member of the coalition that has come together, but certainly those are among the key players. And we at CUNY are extremely pleased to provide the technological help and the resources and the legal expertise to support the webinar. I do want to make it clear that among the many reasons why we are so involved with this critical effort has a lot to do with the fact that the CUNY system is known all throughout the world as a system that is very welcoming of immigrants. And among the most wonderful immigrants in the CUNY system are close to 6,000 students who are seeking degrees who are of Haitian descent. And those are just the students who are seeking degrees. We serve many Haitian students and students of Haitian descent in our adult and continuing education programs, College Now, and in the adult literacy programs on our campuses. We have found over so many years that Haitian students join every other immigrant group in looking to receive the very best possible education. So it's not only that our hearts are with them, our hearts are with them and their families back in Haiti, who obviously have experienced the most devastating nightmare. One of the most important things we can do is to work with the Commissioner for Immigrant Affairs, Fatima Shama, who is a great visionary, and work towards the provision of activities that help Haitian immigrants achieve temporary protected status that will be talked about during this webinar, and as I think everyone knows, was recently provided through an order of the President of the United States. And CUNY is joining with the Mayor's Office of Immigrant Affairs and all the other organizations in preparing to assist Haitians with applications for temporary protected status. So we are just very, very pleased to join with everyone here. Thank you, every person who's participating in this webinar, and God bless you for your wonderful volunteerism.
Thank you, Vice Chancellor Hershenson. We'll proceed very shortly to the program, but I do want to thank a couple of people. First, Sofia Carreño, who welcomed us, who is the Communications Coordinator at Citizenship Now, and also Paul Russo from the School of Professional Studies, who put many, many hours in helping us prepare this in a very short time. For those of you who may be interested in the courses that are offered in immigration at the School of Professional Studies, you should check it out. We have the most advanced immigration studies program in the country. It's open to students, to attorneys, to paraprofessionals. Our two presenters today, as you can see on your screen, are Jojo Annabelle, attorney in charge, Immigration Law Unit at the Legal Aid Society, and Julie Dinerstein, who's the co-director, Immigration Intervention Project, Sanctuary for Families. I'm not going to give any more detailed introduction than that to those two speakers. They are two of the most knowledgeable and expert individuals in the field, and they both have especially strong talent for teaching and explaining very complicated matters in language that hopefully we can all understand. We appreciate all the preparation and attendance. So without further ado, let me introduce Julie Dinerstein, who will start us off. As I mentioned, Julie is the co-director of the Immigration Intervention Project, Sanctuary for Families. Julie, thanks so much for joining us.
Thank you, Alan. I am very glad to be here, so thank all of you who made this possible for putting together this program on such short notice. So our topic today, as we realize, is Temporary Protected Status, TPS. And so our first question is, what is TPS? What is this animal? It is an immigration status for non-immigrants, people who are in the United States and are not going to be able to return to Haiti. The status allows people to live and work in the United States And they're both statutes and regulations that you see posted in your website. So you're going to see some of the resources you can find posted right there in the materials. Right now you're going to see on your screen what TPS is not. This is also going to be really important. TPS is not a travel document. For people currently in the United States granted TPS, this document does not allow them to travel out of the United States and come back. That's going to be an important thing to remind folks. That document for people who are outside the United States, for example, people currently in Haiti, they are not eligible to apply for TPS. They will not be able to enter the United States on TPS. It is only for people here in the United States for benefits in the United States. No crossing any borders. It is not a green card. This is not going to be lawful permanent resident status. It doesn't lead to lawful permanent resident status. It does not lead to citizenship. What is it going to get you to apply for TPS? What's important to know is that upon making out a prima facie case, so filing a valid application, you are granted, by operation of the regulations, you get a stay of deportation if you were previously ordered, deported, or removed, and you are eligible for employment authorization. So somebody who has filed a valid application is going to immediately be eligible for employment authorization, which will be very important. For New York State residents who apply for TPS, once they get a receipt of a valid application, they are also going to be eligible for the New York State equivalent of Medicaid. So they'll be able to get health insurance here in New York State. These benefits are maintained after TPS is granted and goes through the entire TPS period. Unfortunately, not everyone who might immediately think they're going to be eligible for TPS should be filing. There are going to be many people who are Haitians here in the United States who should not file a TPS application. And understanding who should not file is going to be really almost as important as understanding who should file. When somebody applies for TPS, they're going to be fingerprinted. Once a person is fingerprinted, that's going to make their entire criminal record, their immigration record, a whole host of information is going to be available to immigration. And for some people, the information that's going to come up in their history is going to make them ineligible for TPS. And not only ineligible for TPS, but a person who is not eligible may eventually be detained by immigration authorities and deported by immigration authorities. So there are also some downsides to applying to TPS, and you're going to need, if you're working with TPS applicants, you're going to have to help people figure out not only should they apply, but maybe they shouldn't apply. Let's go over and look at the eligibility criteria. What's going to make a person eligible for TPS? The basic points are pretty straightforward. A person either needs to be a Haitian citizen or someone who is stateless, that is with no nationality whatsoever, who last habitually resided in Haiti, and that person is going to have to have been living in the United States since January 12th. So since the day that at least they had to have been here the day the earthquake hit. As I was mentioning, there are people with criminal backgrounds, some security backgrounds, other kinds of backgrounds who are not going to be eligible, and a background that is really specific to TPS, or something in your background that's very specific to TPS, is the designation that anyone with a single felony conviction or 2 misdemeanor convictions is not going to be eligible for TPS. So I'd like to stop now. We're going to have our first poll question. So our first poll question for everyone is this. Jose was born and raised in the Dominican Republic, but when he was 15, he moved to Haiti, though he never became a Haitian citizen. He lived in Haiti until 2007, and then he came to the United States at the age of 35. Can Jose apply for TPS? Okay, thanks everyone for putting your answers in. The majority of you got the answer correct. No, Jose cannot apply for TPS. That is because he is a citizen of the Dominican Republic. You have to either be a Haitian citizen or be somebody who is stateless and last resided in Haiti. As to the question, no, he was not born in Haiti. Again, we're going to be looking to Haitian citizenship law. So the key here for a person who is not stateless is that they are a citizen of Haiti, and there are some people who are not who were not born in Haiti but nonetheless are Haitian citizens. So that's going to be what you're looking for. So moving on, we're going to look at the basics of filing for temporary protected status. So there are two forms that are going to be required for everyone. Those forms are Form I-821 and I-765. Again, I-821 and I-765. I want to stop here and really focus for everyone. The answer to question number 16 on Form 765 is going to be C-19. It's really important that people remember that because U.S. immigration authorities wrongly put out some information on their website saying that the answer to question number 16 was going to be A-12. That information was incorrect, not what people should be answering on their filing. They're trying to update the materials on their website, I understand, but it's important to know if you have some old materials or come across a place where they haven't fixed it, the answer to Form 765 is going to be C-19. In addition to those two forms, everyone is going to need to submit evidence establishing their Haitian nationality, and everyone, or that they are a person without a nationality who last habitually resided in Haiti. They're going to need to submit evidence that they have been both physically present and residing in the United States since January 12th. Everyone is required to submit either a $50 fee or a fee waiver request. This is regardless of age. This is for every single individual filing, the fee or the fee waiver request. And then there are a number of specific requests that are really by age group. So now we're going to turn to the next slides and go to the age-specific requirements. So for people who are 13 years of age or younger on the date that they file, again, 13 or younger on the date of filing, the only fee they're going to have is the $50 fee, again, or fee waiver request. In addition, if those people want work permits, those children 13 and younger, they should include 2 passport photos. The immigration word for work permit is Employment Authorization Document, or EAD. Even though it seems a little counterintuitive, you might think, well, why does a 6-year-old need a work permit or a 1-year-old need a work permit? This is going to be a critical form of immigration identification, and everyone really wants a work permit. I mean, the short answer is everybody wants one, no matter the age. So even for children who have no plans to work, you're going to want to get a work permit, and it is free. The only thing you're going to need are just the 2 passport-style photos. Let's move to the next group. Those are people who are ages 14 to 65. So they're going to have some additional fees that are going to be required. They're going to additionally have what's known as a biometric fee. That is an $80 fee. That's really fancy immigration speak for saying fingerprinting fee. So that's $80. Again, you can request a fee waiver if you're unable to pay for the biometric fee, but that is a second additional fee. There's a third fee that people in this age group, 14 to 65, are going to be paying, and this third fee, for those who want work permits, and again, I suggest that everybody does, is $340. So there's this additional $340 fee. Again, you can request a fee waiver, and then there's going to be 2 passport-style photos. Let's move to our last age group. This is a group of people who are 66 years of age and older. For people in this age group, in addition to your $50 basic fee, there's the $80 biometric fee, which is, again, a fingerprinting fee. And then the work permit is going to be free. So just as with people 13 and younger, the work permit is free, though there is a different additional fee than the fee for children, and that is the $80 biometric fee. Again, you're going to need 2 passport photos for the EAD, the work permit. Let's try to look in a little bit more detail at how people are going to establish that they're Haitian nationals. So there are a couple of regulations that we're going to be looking at that talk about what kinds of documents are required. Best case scenario, your client has a passport saying that they are Haitian. That is going to be your best evidence if you have it. Here, it totally does not matter if the passport's expired or not. The key is that there's this government-issued photo ID, the passport, with your client's picture and name on it. If you've got a passport, that is going to be your best document. If you don't have a passport, other documents that are going to be acceptable include a birth certificate showing that you were born in Haiti. I want to just point out a word on the translations. You're going to need to turn in a certified translation. I see many people going out and paying $50, $100 for some kind of official translation. There is no such thing in the United States as an official translation. Any human being who is competent to translate, in this case, Haitian Creole or French, into English simply needs to write a certification where they certify that they are competent to translate, they've translated the document, and they have translated to the best of their abilities. Where there's no birth certificate, the third document listed in this regulation is any kind of national identity document showing that you are from Haiti. Then there's some regulations on secondary evidence. What are you going to do if you don't have, if you are a Haitian or you're assisting somebody who's Haitian and that person doesn't have a passport, that person doesn't have a birth certificate? Obviously, right now, if you don't have documents showing that you're from Haiti, it's going to be very difficult, or more likely impossible, to try to get friends or family members back home to find those documents, get them, and mail them to you here in the United States. So there are rules around secondary evidence. I've posted some of the secondary evidence rules on there, the regulations, but there's sort of a key point to keep in mind. You're going to do the best you can. Among the best forms of secondary evidence are two adults who know of the events that you are trying to verify. In this case, when you're trying to verify that somebody was born in Haiti, you may be looking for older family members, people from the same village, community, neighborhood, who knew of your birth at the time that you were born. So two affidavits from people who knew your family at the time you were born and have very specific detailed information about where and when you were born are going to be your best proxies for a lack of a birth certificate if that's the document that you are looking for. As we look in the next slides, we're going to talk a little bit about brainstorming because there are going to be a few things. It would be great to have a passport. It would be great to have two older family members who live with you who could now provide affidavits, but not everyone's going to have that. So we're going to have to think creatively, and you're going to be working with people who are applying for TPS to think creatively about what kinds of documents they may be able to come up with. There are going to be a lot of government documents, official documents out in the world that suggest that a person is born in Haiti or show that that person is born in Haiti. So, for example, if somebody had children who were born in New York City, their birth certificates are going to list the place of birth of the parents. If somebody has a child born 5 years ago, that birth certificate will show that they were born in Haiti. There wouldn't have been any motivation to lie at that time. They would have simply stated what was correct. The same are true for marriage certificates here in New York. They show the place of birth of each person getting married. A person can request their FBI records, particularly people who've had interactions with the criminal justice system. This may be something they want to do anyways to make sure they understand their criminal record and understand whether or not they are going to be eligible to apply for TPS. FBI records frequently reflect the place that a person was born. Government records from Haiti. Somebody may not have their birth certificate or a passport, but they may have other interactions with the government that are documented that they can now provide copies of. Marriage records, divorce records, tax records, anything that tends to go towards the fact that suggests someone is either treated as a Haitian citizen here in New York or has documents showing that they were treated as a Haitian citizen by the Haitian government. Let's look at the poll question right now. We have another one, so I hope folks are listening. Which of the following would you use to establish your Haitian nationality? Would it be a statement from your pastor where you go to church in Brooklyn, a statement from your younger sister, or a statement from your aunt who came to take care of your siblings, who came to take care of you and your siblings when you were young? Okay, so I see the majority of you were listening when I suggested that an older family member who might actually know about your birth and be able to provide specific information, that might be your aunt who took care of you as a child, that's probably going to be your best statement. Also, a statement from your younger sister, a statement from your pastor, those are great things to add into your applications. But if you do have an older family member, older community member who knew you at your birth, that's going to be your strongest sort of outside supporting statements. a few quick words about establishing your Haitian national identity and helping people too. It's important to remember that Haiti has an active and open consulate here in New York City, as well as an embassy in Washington, D.C. So we provide the information to you there. And then in our next slide, I just want to make a practice tip that we have in our next slide, and that is, if you work with a TPS applicant, they don't currently have a passport, a current valid passport on the date that you file, it's a great idea to encourage them after you file your application to try to get a Haitian passport. I understand from members of the community that you can often go, for those who can travel to Washington, D.C., if you can get there early in the morning, it is often possible for the Haitian embassy in Washington, D.C. to process a passport application in one day. That passport is going to be very helpful later on as a general government form of ID, and also when you go to get fingerprinted in connection with your immigration application. And it is also possible to submit applications for a passport for people who have the requisite documents here at the consulate in New York City, though all of those documents are going to be sent to Washington, D.C. The next thing I'd like to talk about is establishing your presence on January 12th, 2010, and your ongoing residence. You know, in an ideal world, you've got a parking ticket on January 12th, or some major event happened on January 12th. You were in the newspaper here in New York City on January 12th. But for most people, that's not going to be the case. So, as a general rule, you start out by trying to prove you were here before January 12th. Because for a lot of people, over the course of time, they have a lot of interactions. They're going to be able to show that they were here prior to January 12th, and that's going to go a long way towards establishing their presence on January 12th. So certainly, anybody who made a lawful entry into the United States, now that's not going to be everybody you meet. There is no lawful entry requirement for a TPS applicant. But if you did make a lawful entry at some time prior to January 12th, 2010, you're certainly going to want to submit proof of that. So I think you see on your screen a number of stamps in passports. If you've got a stamp like that, and the most recent one is before January 12th, 2010, that's going to be certainly very helpful. A photocopy of that stamp should be included. Most people entering the U.S. lawfully who are not citizens or green cards holders receive I-94 cards, the little white cards. A photocopy of that card would be great to include in your application. Some people here in the United States have filed other kinds of immigration applications, received other documents from immigration authorities in connection with other kinds of cases. Proof of those other filings or correspondence with immigration is great, and there's no time like the present to point out that somebody who has another immigration status, they're not a U.S. citizen, they have another valid immigration status here in the U.S., can in fact apply for TPS. So just because the person has a valid F1 visa or F1 status, valid H1B status, that person can also be applying for TPS, and they can use the fact of their other immigration status, their student status, their employment authorization in some other context. They can use copies of those kinds of documents to show that they're here in the U.S. For many people, however, maybe they didn't make a lawful entry or they lost their documents, they don't have great official immigration documents, but there are a lot of documents that people go through in daily life that show that they've been living here. Employment records, tax records, all sorts of bills that people get all the time, school records either for themselves, their kids may be in school here, medical records for themselves or their kids, birth certificates of children who are born here, attestations from all sorts of people. We like to see, if possible, attestations from people with churches, unions, other kinds of organizations, people who are not self-interested in helping you out. But if you have nothing else, I would certainly take statements from community members, friends, family, any kind of financial records. We know that a lot of immigrants, for example, are going to be sending money home to Haiti. So if you have receipts from Western Union, receipts from sending money abroad, or you may have a bank account, any kind of records relating to cars, any government records. And when it comes right down to it, just anything you have. If you have junk mail in your name in Brooklyn, send in a photocopy. Anything that's going to tend to show you're physically present here. For a lot of people, the fees and the fee waivers are going to be maybe the scariest part of the application, because it is a lot of money, and particularly when you have a number of family members applying, you're talking about a lot of money for these applications. So for people who are able to pay the fees are going to be paid to the Department of Homeland Security. That's who the check is made out to. Note that if you have a personal check, as long as it doesn't bounce, it is going to be good for your application, or you can submit a money order. Immigration urges you, they don't require, but they really urge you to make sure that you're going to be having out individual fees. So for example, if there are 3 fees in your application, a $50 fee, an $80 fee, a $340 fee, if you can do it, it is best to have each individual fee in its own check or money order, and certainly make sure that you are only submitting fees for one family member. Think of it, one family member per envelope, one payment per envelope. You're not going to want to be mixing up those fees. Fee waivers are going to be available. Immigration is supposed to be applying them liberally, but I can tell you as an immigration attorney who files the majority of my cases with fee waiver applications, it does slow the process down. So those who are able to pay, it's a good idea. If people really can't, they are able to apply for fee waiver. There is a general fee waiver rule, and the general fee waiver rule, which you should see on your screen right now, just tells you that you have to make a specific request for each fee you want waived. So for example, if there's a $50 fee, an $80 fee, and a $340 fee, you have to specifically request for each of these fees to be waived. You have to either swear in a declaration, a declaration where you say under penalty of perjury that you're not lying, or a notarized statement. You have to describe what is your inability to pay. Why can't you afford the fees? As we'll see in the next slide, the TPS regulations provide a little bit more guidance about actually what immigration would like to see. They're actually asking about your last 3 months' income. They want you to describe what has been your income, gross income over the last 3 months, what are your assets, what are your essential expenditures, as we see on the next slide at Little Roman 3, what are your, who are your dependents, who are you supporting, and then submit whatever documents you think you have that are going to help show that. If we go to our next slide, you see that the fee waivers are always going to be available. You certainly should be providing any information about public benefits that you or any of your family members are receiving. If you have evidence that your family is below the federal poverty guidelines, you should absolutely be submitting that, though it's not a technical requirement, and any kind of heavy expenses that you might have. And there's just a few more slides that really go towards this general idea of the fee waivers. A couple of practice tips that we have for you. This is not a tax filing. You don't need to say if you made $866.12 last month. You can approximate. If you think you made about $900,000 last month, you can say that. And if you don't know the exact amount, you can talk about that you're making an approximation. That's okay. So let's go to our next poll question. Marie is a single woman with no children. She has been working off the books as a home health aide and makes about $400 a week. She makes about 2 times the poverty level, but money is tight because she sends most of her money home to her elderly parents. Is she going to qualify for a fee waiver? We have about 50-50 saying whether or not Marie is going to be eligible for a fee waiver. And I actually think you're both right. This one's going to be a little bit of a close call. Marie is living at twice the poverty line, so that double the poverty line, and so that might, depending on the adjudicator you get, that might be a little bit of an iffy question. On the other hand, if Marie lives in New York, she may well be paying $800, $900, $1,000 for her room alone, and by the time she pays for her Metro card and her food, she's probably doesn't have that much left over. So this is an example where it's a little bit iffy. Her fee waiver might be approved, her fee waiver might be denied. If there's a way she can come up with the money, I think that that's great. If she wants to try for a fee waiver, it might be approved, it might not. She can certainly try. I just want to point out next, where are we going to be sending these applications? Very important to know, particularly if you find people coming in from Connecticut, people coming in from New Jersey. There are specific addresses for New York State and New York State residents only. So we've listed those for you on the screen. If you are assisting somebody who does not live in New York, somebody who lives in New Jersey, somebody who lives in Connecticut, somebody who lives somewhere else, they are not going to be filing to these addresses. You're going to have to look up those addresses on the USCIS website or in the Federal Register notice. Then I just have just a few practice tips for you. You're not going to be wanting to send original documents that are used for another purpose. JoJo's going to talk to you about the original criminal record documents that you might be submitting, but you're never going to submit an original birth certificate, property deed, passport, anything like that. People will always need copies of what they file. You never want to be without a copy of a document that you file with the federal government. You want to have proof of filing, so you're going to be submitting by some kind of return receipt, either from the post office or a courier service, and you want to make sure that you only have one family member per envelope. They get quite confused in the mailroom when they have more than one person's application in an envelope. Then I'm going to just leave you with some final tips on post-filing. It's going to be very important that people keep immigration aware of their records. There's actually a federal requirement that any non-citizen file a change of address on Form AR-11 within 10 days of moving. So people have to make sure that they've let the government know that they've moved. If at the time that that person moves, they have a pending TPS application, if you file the AR-11 online, there's actually a place to put in your pending application receipt number and make sure that that change of address connects up with your pending application. For folks who don't have access to the internet at home or at work, it's important to know that you can go to any New York City public library and they can help you get online. The final couple of tips, as I mentioned before, the receipt for the TPS application is going to be enough to make a person eligible for health insurance in New York State. Once a person receives their EAD or their work permit, they're going to be eligible to apply for Social Security number. There are special rules for Social Security number applications for Brooklyn and Queens residents, which I believe is going to be the bulk of the people that we're serving. And then the final couple of post-filing tips that I want to mention is that it is critical all non-citizen males who are living in the U.S. between the ages of 18 and 26 must register for selective service. This is a legal requirement. It's also a ground of deportability if you do not register for selective service, a ground to have a citizenship application denied later on. So make sure you let folks know they've got to sign up for selective service if they're male between 18 and 26. And for New York residents who've lived here for more than a year, once they've been granted TPS status, they're going to be eligible for in-state tuition. So, for example, people who've been in F1 status before may want to move to the lower rate, the in-state tuition rate, once they've been granted TPS. And with that, Alan, I'm going to hand it back to you.
Thank you so much, Julie. That was terrific. And I remind our listeners that we will have time for questions after JoJo Annabelle makes his presentation. For most of the applicants that we serve in these application assistance events, the most difficult aspect of their applications are going to be proving that they're Haitian and proving that they were here on January 12th. But some of our applicants are going to have more difficult problems, particularly to address, and more complicated issues, particularly those who have criminal records. Thanks to JoJo Annabelle, supervising attorney, immigration law unit at the Legal Aid Society, who will be addressing you next. We will be learning quite a bit about that today. So JoJo, we thank you so much for joining us, and we look forward to your presentation.
Alan, thank you very much. It's a pleasure to be here, and I'm glad that I'm able to do this. Julie just went through part 1 of the TPS application form IA-21, and the focus of my presentation will be part 2 of that application. Part 2 of the TPS application form IA-21 asks 37 questions related to criminal and illegal activity. A yes answer requires a written explanation, and a conviction requires a certified certificate of disposition. What I'm going to do is to go through the criminal bars which would make someone ineligible for TPS. I'll also look at some of the crime-related grounds of inadmissibility, and also some of the bars which may be waived in the public interest for humanitarian purposes and to assure family unity. A note of caution: the intersection between immigration and criminal law is very complex. If you are assisting a Haitian national who has a prior arrest or conviction, you should please speak with an immigration specialist. The stakes are just too high. In slide 1, we have highlighted one of the 37 questions on the application just for illustration. The question asks if you've ever been arrested, cited, charged, indicted, fined, or imprisoned for breaking or violating any law or ordinance. Depending on who is asking the question, how it's asked, and who is answering this question, a lot of times you get a no answer. Volunteers need to go a step further when they ask this question and probe a little bit more to find out any contact with law enforcement. Have you ever been fingerprinted? Have you ever been stopped by the police, detained by the police, or questioned by the police? What you have to also let your clients know, and you need to caution them, is that they need to tell the truth about convictions and arrests, because USCIS will find out. USCIS now requires anyone who is applying for an immigration benefit to submit their fingerprints. And this generates an FBI rap sheet. And so if you don't tell the truth, or if you don't disclose an arrest or a conviction, it's also possible that could just lead to a denial of your application. If the client has a conviction, you should ask the client to go to the courthouse where the case was heard and request a certified certificate of disposition. USCIS will not accept a copy. In some instances, a client will tell you that there was an arrest, but the charges were dropped, or the victim, declined to press charges. They would need to contact the prosecutor's office and get a letter. The form says that if you've ever had an arrest, you have to show some kind of disposition. So with that preliminary introduction, we should go to our poll question number 1 for this presentation. Felipe is not sure if he was arrested. He was with a group of friends on the corner, and the police rounded them all up and brought them to the precinct. Actually, he was pretty drunk and cannot remember it was even fingerprinted. What should we do? So it looks like our poll numbers are in, and 97% of you think that he should not apply as yet. He should first try and get some document. Yes, you're right. He could also ask his friends, who are probably sober than he was, what happened that day. Or he can also find out, go to the criminal court, go to the summons part, and find out if, for example, there's a warrant out there for his arrest. Or we could do a criminal search on the Office of Court Administration, which sometimes is not too easy because you can't do a name search, but you all have it right, and Felipe has to wait and do some more research, go and look for these documents before he decides to apply for TPS. Okay, so thank you very much. Moving on, so we're looking at this in 3 parts. Part 1 would be criminal convictions which would bar someone from TPS. Then we'll look at grounds of inadmissibility, crime-related, which would bar someone from TPS. Then we'll look thirdly at inadmissibility grounds that bars someone, but that person can apply for a waiver. So looking at the criminal bars to TPS, any felony conviction or 2 or more misdemeanor convictions committed in the United States at any time would make a person ineligible for TPS. Non-citizens with felony or 2 or more misdemeanor convictions who apply for TPS risk having their applications denied and referred to an immigration judge for removal proceedings. There is no statute of limitations, so it doesn't matter whether the conviction was decades old. The regulation defines felony and misdemeanor. Felony is defined basically as any crime punishable by an imprisonment of more than a year, irrespective of actual confinement. A misdemeanor is defined as any crime punishable by up to a year in jail. These two definitions compare with New York State's classification of felonies and misdemeanors, and that definition applies to New York. However, in some jurisdictions where you have felonies, crimes classified as felonies, but where the maximum possible punishment is a year or less than a year, or you may have situations in some jurisdictions where a crime is classified as a misdemeanor, but the potential sentence is more than a year. If that is the case, then that would be a felony, or if it's a felony, but the potential sentence is less than a year, then it's a misdemeanor. If you have out-of-state convictions, you should ask to review, you should research the criminal statute for that provision to see what the maximum possible, the potential sentence was. Because that is the key. It's not how much time the person spent in jail or what sentence was imposed. It's what the statute charges, the statute's maximum possible punishment. The statute also, or the regs also talks about any crime punishable by a maximum of 5 days or less is not a felony or a misdemeanor. For some time now, USCIS had interpreted this broadly to include New York City traffic infractions and also non-criminal violations, which usually carry a maximum jail time of 15 days. Thanks to Professor Nancy Morowitz and her students from the Immigration Rights Clinic, the New York University Immigration Rights Clinic, USCIS just this week issued guidelines to its officers instructing them that New York City traffic infractions and New York City non-criminal violations do not constitute misdemeanors and so would not bar someone from TPS. We've highlighted a few of these New York non-criminal violations: driving without a license, possession of an open container of alcohol, loitering, harassment, speeding, or littering in the New York City subway. We've put a cautionary note on marijuana violation under the Penal Law 22105, because even though it's not a misdemeanor under this category, it has other consequences, which I will talk about later on. Having said that, we should go to our next poll question. Jean Cloud was convicted of a misdemeanor for assault and also for disorderly conduct. Is Jean Cloud eligible for TPS? $59% of you said that yes, he can apply because disorderly conduct
It's not a misdemeanor.
Is not a misdemeanor. You are correct. So in this question, what you have is he has one misdemeanor, and we're looking at a felony or two misdemeanors or more. And he only has one misdemeanor, and the disorderly conduct is only a violation under the New York State penal law. And so Jean Cloud is eligible. However, in this example, Jean Cloud also has to be careful, because let's say he's able to obtain TPS, but soon after he obtained TPS, he jumps the turnstile at a subway. That's theft of services. It's an A misdemeanor. It will make him ineligible if TPS is renewed at a certain point in time. So just to keep that in context. Just before I go on, I misspoke a minute ago when I talked about New York City traffic infractions. I meant New York State traffic infractions, so sorry for that. So just to recap, we've talked about if someone has a felony conviction or has 2 misdemeanor or more convictions. Under immigration law, anyone who is seeking an immigration benefit needs to prove that he or she is admissible. Congress has promulgated certain provisions, some related to health, some related to economic, some related to immigration violations, some crime-related, some security-related provisions, which would make someone ineligible or unable to come to the United States or unable to get an immigration benefit. And so there are crime-related grounds of inadmissibility. Under the statute, there are 4 crime-related grounds that would make someone ineligible for TPS. Any conviction or admission to the commission of a controlled substance offense or a crime involving moral turpitude, which I'll go into at a later point, would make someone ineligible for TPS. What we're talking about here is not even whether, it doesn't matter that it's a misdemeanor or it's a violation, because we talked about the marijuana violation, which would fall under this controlled substance offense. They also list conviction of 2 or more offenses with an aggregate sentence of 5 years. This will usually be covered under the felony that we just considered. Then there's another category, reason to believe a drug trafficker, which basically is something that USCIS makes that determination. For example, Felipe was arrested with 50 pounds of marijuana. Felipe goes to court. He has an excellent, a brilliant lawyer who challenges the search. And so the case is thrown out, and Felipe walks out of there just that he lost 50 pounds of marijuana. Immigration can make a determination if Felipe is questioned about that arrest, that because he was arrested with 50 pounds of marijuana, they have reason to believe he is a drug trafficker. The only exception for this under the statute is 30 grams, possession of 30 grams or less of controlled substance. All these crime-related grounds that I've just mentioned, controlled substance offense, crime involving moral turpitude, conviction of 2 or more offenses with an aggregate sentence of 5 years, reason to believe a drug trafficker, cannot be waived. If you have a client who has any of these convictions, that person is not eligible for TPS. We've looked at both conviction for felony, conviction for misdemeanors. How does immigration define a conviction? In 1996, Congress finally decided to define what constitutes a conviction for immigration purposes. And that can be found under the statute 101A48. And it's in 2 parts. The first one is any formal judgment of guilt. So any plea or where there's a finding of guilt and then there's a sentence. Everything is over. The second one basically covers nearly a lot of crimes that we have in New York, which are usually minor crimes. Any deferred adjudications where there's a finding of guilt, where someone pleads guilty, and the judge orders the person into some program or imposes some conditions, and upon successful completion of those conditions, or let's say a drug rehab, the person comes back into court and the conviction, the plea, either he's allowed to take his plea back and plead to something less, usually which would not pose problems for immigration purposes, or it's dismissed altogether. So in that situation, for state purposes, the person doesn't have a conviction. Under the definition that you have here of a conviction for immigration purposes, that person still has a conviction because there was a plea and the judge ordered some form of restraint on his liberty or some punishment or some penalty. So under those circumstances, you find out that the state has decided that the person doesn't have a conviction, but immigration says he has a conviction. And so that person could come under any of the ground, that the ineligibility bars that I've just talked about. The aspect of penalty, punishment, restraint on an alien's liberty has been interpreted broadly, and we've given you some examples, including community service, surcharges, fines, and drug rehab programs. So having made this broad statement that conviction for immigration purposes is very broad, what is a conviction? What is not a conviction for immigration purposes? So what is not a conviction for immigration purposes? Any disposition in family court, because it's civil in nature, and here we are talking about criminal convictions. Any deferred adjudication where, for example, you're ordered into a drug treatment or anger management or counseling, but where you're not required to take a plea before you start the program, then it doesn't satisfy the definition of a conviction. A conviction on direct appeal is not final, and so you cannot, someone who has a conviction but it's on direct appeal, doesn't have a conviction and will be eligible for TPS, for example. Juvenile delinquent is also not a conviction for immigration purposes. Youthful offender adjudication is also not a conviction, because usually what happens is that the minor takes a plea, applies for youthful offender adjudication, and once it's granted, the plea is vacated. And so you don't have the second prong of the definition of a conviction. What would be a conviction? I just talked about one, deferred adjudication, where the person takes a plea, is ordered into a program, comes back, and either he takes his plea back, he pleads to something lesser, he pleads to a lesser crime or even a violation. For immigration purposes, it satisfies the definition of a conviction because there was a plea and the judge ordered a restraint on the person's liberty, which is the drug rehab program. A conviction that's on collateral attack, not on direct appeal, is also a conviction for immigration purposes. Where someone tries to vacate his conviction because he faces, he has problems being able to get eligibility for TPS. That's the sole purpose. It's not because of some legal defect. Immigration will still consider that a conviction. Also, juvenile offenders, minors who are tried as adults, would be a conviction. So having talked about that, I keep recapping, but we've talked about felonies, we've talked about 2 or more misdemeanors, we've talked about controlled substances, we've talked about crimes involving moral turpitude. Those 2 are the most common crimes that you will come across. Crime involving moral turpitude, controlled substances. So we should look a little bit at crimes involving moral turpitude. Congress has never defined what is a crime involving moral turpitude. The definition you see there is something that has evolved over time and was developed through case law. But basically, a crime involving moral turpitude covers any intent crimes, intent to steal, intent to defraud, intent to deceive, intent to cause damage to property, bodily harm, recklessly causing serious physical injury. All these are intent crimes, sex offenses. Sometimes they look at the victim, who is involved. Is it a domestic partner? Is it a child? And so if you're looking at crimes involving moral turpitude, a lot of times you need to look at cases because it's developed through cases. I don't expect a lot of you to do that development because there are experts out there who have been doing this for a long time and would be able to help. But crimes involving moral turpitude, so if you have someone who has a crime involving moral turpitude, it's an assault misdemeanor, and it doesn't fall within the first category we talked about, 2 or more misdemeanors. However, it falls within the second category we talked about, crime involving moral turpitude. Is that the end of the road? No, it's not. There's one last chance, and that last chance is a petty offense exception. There are two exceptions to the crimes involving moral turpitude. The first exception is this. It's called a petty offense exception, where the crime is punishable by up to a year. So in New York, it could be a misdemeanor. And the sentence imposed is 6 months or less. The person gets an exception. It's not a waiver, it's an exception. It's almost like it doesn't exist for immigration purposes. Just one, and you only have to have one. If you have more than one, you are ineligible for the petty offense exception. So for example, if you had 2 misdemeanors involving assault, you cannot have the petty offense exception take one off the record. No, you would have 2. You only can use it with one. You also have a youth exception. Anyone who committed an offense under the age of 18 and is filing or making an application for admission 5 years after the commission of the crime or after any confinement would also get this exception. Those are the only 2 exceptions for crimes involving moral turpitude. Usually, the approach in looking at crimes involving moral turpitude, people have adopted different approaches at looking at it, but the most common one is a categorical approach, meaning that when you're looking at a crime involving moral turpitude, you're only looking at the statute, the elements of the statute. You don't look at the underlying facts. If, for example, the statute has many sections, multiple sections, and some of the sections would make someone, some of the sections constitute a crime involving moral turpitude and others do not, then you do a categorical modified approach. What that means is that you only can look at the record of conviction, which comprises just of the plea and sentence minutes and the indictment or the complaint. You cannot look at the police records. You cannot look at the pre-sentence report. Okay, so that's for crimes involving moral turpitude. As I said, it could be a misdemeanor, but you have an exception, and it has to be just one single CIMT. So controlled substances, also a big one. Because sometimes you hear people talk about, I was just smoking marijuana in the park, and as if that's okay, we went to court and I took a violation. It's problematic because under federal law, possession of marijuana is a crime. In some of the states, for example, in New York, some possession of marijuana is just a violation, which we've just talked about. For immigration purposes, however, it's a controlled substance. And so it will make someone ineligible for TPS. Possession of drug paraphernalia, having a coke pipe or whatever people use to use with drugs would make someone ineligible for TPS. Driving under the influence where it involves drugs also is one such factor. So again, to recap, we go back to our felony, 2 or more misdemeanors. We've gone through our controlled substances, CIMT, 2 or more offenses with an aggregate sentence of 5 years, reason to believe a drug trafficker. Are we through? No, there's one more step to go. The one more step to go, and if you look at the questions in the form IA-21, a majority of those questions fall under this. So you have grounds of inadmissibility. Some of these are health-related, some of these are economic-related, security-related, immigration violation-related. They would make someone ineligible for TPS. However, the statute provides a waiver for someone who can show that he deserves a waiver in the public interest for humanitarian purposes or to assure family unity. What do you have to do? A person who, for example, has prostitution convictions, has engaged in alien smuggling, helped people come through the border, has falsely claimed to be a U.S. citizen, was deported some time back, can get a waiver. You have to file an I-601, and you need to attach that I-601 a statement, for example, indicating what happened, because that is what is required. You need to explain why the incident happened. You also need to show mitigating factors. For example, if it was a conviction, rehabilitation, family ties. Some people can show medical condition or can show that they can't go back because they are the sole breadwinner and that's their family needs them. So you need to file an I-601. When do you file it? You need to file it with your application. It would have to go with the application. And so having said that, we should go into our next poll question. Isabel was forced into prostitution by a terrible aunt who she was living with. She was arrested and convicted of prostitution 4 separate times. Can Isabel apply for TPS?
Jojo, while we're waiting for the answer, I just want to clarify one point that you made about the controlled substance offenses. I believe you made a mention of a waiver that might be available. Am I correct that that waiver would only be available for a single conviction or of an offense that involved 30 grams or less of marijuana, simple possession, and that any other controlled offense violations or even 2 marijuana convictions would not be waivable?
That's true. However, if you look at the statute closely, that waiver is linked to the reason to believe a person is a drug trafficker. And research is being done currently to find out if it's in the wrong place, because it just doesn't make sense in the statute. Because reason to believe a drug trafficker relates to distribution or sale of drugs and will come nowhere close to just possession of 30 grams. The possession of a single possession of 30 grams of marijuana really belongs to the controlled substance category. And so there's some research being done, because it looks like the statute was changed back in 1990, just before then, and some part of the section was taken out, and this section was left in there with the reason to believe drug trafficker provision. So having answered Alan's question, we will not be relying on that waiver that we just spoke about, and we'll just be doing straight applications and wait until USCIS makes a determination on that. So the poll numbers are in, and it looks like we're doing a great job. People understand what we're talking about, but again, realize that this is a very complex area, and there's a need to reach out to an immigration specialist, because you will not find these easy situations. Most of these things are more complicated than they look. So going back into my presentation, apart from the felonies, the misdemeanors, and the crime-related grounds, there are also other bars to TPS, and there are bars that usually apply to people applying for asylum and also withholding, that have been made applicable to TPS applicants, and talks about anyone who has at any point in time persecuted others, anyone who is convicted of a particularly serious crime in what they call an aggravated felony offense, or any serious non-political crime outside the United States, or constitutes a danger to security of the United States. So let's move on to the very last segment of this presentation. What happens to those who have been in removal proceedings or who are currently in removal proceedings? On January 13th, the government announced that it has suspended deportations of all Haitians with final orders of removal, meaning Haitians who had cases in immigration court or had filed appeals before the Board of Immigration Appeals, and these cases had been decided, and so they have final orders of deportation. If a person is detained with a final order of deportation, it's possible that the person can ask to be released. Immigration and Customs Enforcement usually would make these determinations on a case-by-case basis, looking at the person, if the person is a danger to the community, or looking at if the person is a flight risk and would not show up again. If if a Haitian national is released from immigration detention and put on ordered and put on supervised release, what happens is that he's eligible to apply for employment authorization. That person may not be eligible for TPS because he or she may have some criminal convictions, but the statute allows them to apply for an employment authorization. If the person is not detained but has a final order, the person may be eligible for TPS. For example, someone who has a final order because he failed to show up in court, or someone whose asylum application was denied in court may be able to apply for TPS. If they have criminal convictions, on the other hand, they may not be eligible. What about those who are currently in immigration proceedings? According to the regulations, the Executive Office of Immigration Review, which oversees the immigration judges, is supposed to give written instructions to Haitian nationals who are facing removal proceedings. If there's a Haitian national out there who is in removal proceedings, and those proceedings are coming up soon, within the next 2 or 3 weeks, that person should go to court and inform the judge that he's a Haitian national and will be applying for TPS. The judge is going to continue the case and give the client an opportunity to apply for TPS. Once he can show that he's applied for TPS and is eligible for TPS, it's very possible that the judge will administratively close his case in removal proceedings, meaning that the judge basically closes his case until conditions improve in Haiti or until TPS is revoked. So once TPS is revoked, the case is back on the judge's calendar. I'm sorry about that. If the person has a long adjournment, so let's say someone has a case coming up in court in 3 months, then the person would be able to apply for TPS now, go into court, show proof of having filed for TPS or a receipt notice, and ask that the case be administratively closed. If anyone needs assistance doing this, there's an immigration representation project at 26 Federal Plaza, and you should look up the schedule. It's in room 1207. It's held 1 week every month, and you would be able to get assistance from that project. So having said that, we should look at our next poll question. Michel came to the U.S. in a boat in 1991 from Haiti. He was caught by immigration on the beach at Miami and given a court date and released. He moved to New York City and never went to his court date. He was ordered deported in absentia for not showing up. Can he apply for TPS? Well, in this case, yes, final orders have been suspended. He can go and he can apply for TPS, even though he has a final order. He can apply for TPS and also apply for employment authorization, provided again that in the meantime he hasn't committed any offenses which would make him ineligible for TPS. Having said that, I started off this presentation and basically asked that this area is very complex. Even though it's very easy to remember that a felony would make someone ineligible for TPS, we've also talked about the fact that that classification sometimes is different in different states, and so you'd have to do some research into that. We've talked about controlled substances. We've talked about the crimes involving moral turpitude, with a one petty exception and also the youth exception. However, I'm just urging all of you out there who are going to volunteer, if you come across anyone who has an arrest or a conviction, please ask the person to collect documents, and that person can seek help in reviewing those documents to see whether he or she can apply for TPS. It's very important that we do that. We do not want to put anyone at risk of being placed in removal proceedings. If you need assistance figuring out arrests and convictions, please call the Legal Aid Society's Immigration Law Unit at 212-577-3292 or the Immigrant Defense Project Hotline at 212-725-6422 on Tuesdays and Thursdays. I thank you all for listening in, and it's a pleasure being able to do this today. Thank you.
Thanks so much, Jojo. That was really terrific. I think you'll agree that we've had two very outstanding presentations. This is going to be a process where there'll be constant consultation amongst ourselves, and now's the time for you to ask some of your questions. We have with us Midori Hills. We don't have her photo, but she is the Director of Legal Services for CUNY Citizenship Now. We want to thank her for monitoring the question and answer portion of the rest of the webinar.
So I've been monitoring the questions over the course of the this webinar, and we've gotten a lot of interesting questions, and so I'm just going to read them out, and we'll see what Julie and Jojo have to say about it. So one good question that came in was, when applying for TPS, does every family member need to file a separate application and pay the fees? So, in other words, does a husband and the wife and three minor children mean there have to be 5 applications, or can everybody go in on one?
That's a great question, and it's important to realize that each and every individual family member needs their own application. So where you have mom and dad and 3 kids, that's 5 separate people who are going to be applying for TPS. You need 5 separate applications. You're going to need separate fees for each family member, and I'm going to very strongly urge you, each of those family members' individual applications is going to go in a separate mailing envelope. You will be very happy you did it this way.
Okay, let's see what else. We also had one question that came in was, I guess this one would be for Jojo. When are people supposed to research the statutes to see what the offense or punishment was, and whether there would be resources available at the events that we're having where folks are volunteering?
Well, at most of the events, there's going to be an immigration specialist who has immigration and criminal law, who is an immigration and criminal law expert. And so I don't expect the volunteers to do the research. All we are asking is at least to get information from the client to be able to figure out whether the disposition is a conviction for immigration purposes. So you'd have an opportunity to consult with an immigration specialist at most of these events. So rest assured, you don't have to do research. You don't have to do any further work on this.
And in fact, one of the things that we always stress is that because the area of immigration and criminal law where they intersect is so important and has such serious consequences, that people should not try to do guesswork, and that always try to find someone who's going to be knowledgeable in that field. And we're very lucky to have this relationship. CUNY's lucky to have this relationship with the Legal Aid Society to be able to help us with these things. Also, we'll be making a correction to one of the slides that has the phone number. This is the phone number for the Legal Aid Society that was posted before. I'll give it to you now, and then you'll see it again if you go to the website to look at the webinar afterwards. The phone number for the Legal Aid Society is 212-577-3300, 3300.
And somebody asked, a question just came in about whether you'll be able to get copies of these slides. Certainly by Monday morning at the latest, the slides and the video of this webinar and audio will be available for downloading.
Okay. All right. Another good question we got was about fee waivers and whether when requesting the fee waiver, is it just one document for all the forms and fees, or do you need a separate fee waiver for each separate fee, like one for the fingerprints and one for the work authorization and one for the TPS application?
That's a great application. What you need to do is you need to specifically ask for a fee waiver for each of the applications. So what you can do on a single piece of paper, you can say, I am asking for a fee waiver for the TPS application on Form I-821, for the work permit application on Form I-765, and for the biometric fee. So you need to specifically ask for the fee waiver for each fee you want waived. So you need to spell it out, but that can be done in one piece of paper. Or you could do it in 3 if you prefer.
Okay, let's see what else. There was also a question about whether someone who is a dual citizen can apply for TPS, so it would be someone who is a citizen of Haiti and then also a citizen of another country.
Absolutely. You can absolutely apply for TPS. The requirement is either that you're a citizen of Haiti or that you're stateless. If you're a citizen of Haiti and somewhere else, that's not going to disqualify you. The key here is that you are a citizen of Haiti for the nationality requirement.
Okay. And another question, this question actually started coming in pretty much as soon as we started the program, and I knew that Jojo was going to get to it in his section, but I think it, because so many people asked, I'll just mention it again. And it was a question about people who have final orders of removal. If they have old deportation orders, what they should do in order to apply for TPS.
So as I mentioned in the presentation, if someone has a final order, that person would be eligible to apply for TPS provided the person doesn't have any of the criminal bars. If the person doesn't have any conviction, felony, misdemeanor, or controlled substances, or a CIMT, that person will be eligible to apply for TPS, even though they have the final order.
Okay. There are a lot of questions. The questions are coming in fast and furious, so it's a little bit hard for me to get through them. So let me see. This question's not 100% TPS related, but I thought it was a good one. If someone's going to fill out a FOIA to try to get their FBI records, I guess there was a concern about whether there would be enough time before the 6-month application period was over. I don't know how long those FOIA requests are taking or those FBI requests are taking.
The FOIA request for an A file or for the rap sheet?
Yeah, for the rap sheet.
Usually it takes, I think it's taking about 6 to 8 weeks.
Oh, fine. Okay, so if it takes 6 to 8 weeks, as long as people get on it right away, then they should have enough time to apply before the end of the registration period.
And I just want to make clear on getting your records, your FBI prints. For people who really don't understand what their interactions with the criminal justice system has been, and I would say that is really a large number of people I see in my day-to-day practice as an immigration lawyer, it's really much better to make sure you understand your criminal record first before you let immigration figure it out for you. You're going to be putting yourself at risk once you file a TPS application. So particularly when you're helping people right up front right now and there's a 6-month application period, they should absolutely go ahead, try to get their FBI prints get their rap sheet back, and make sure that they work with an immigration and criminal a specialist who works in the overlap of immigration law and criminal law to make sure that they're eligible and they're not placing themselves at risk when filing a TPS application.
I got a question about documentation. I guess what kind of proof I know we talked about this earlier, but what kind of proof can someone show where they're working off the books and their employer doesn't want to write a letter because the employer doesn't want to get in trouble for having hired someone who's unauthorized to work. So what can they do? Like, can they use like Western Union receipts, or like what can they show?
That's a great question. What to do when you're working off the books? So one of the first things that I always let my clients know is that you have a tax obligation when you're working on the United States. You're working on the books, you're working off the books, money is being mailed to you from a foreign country. If you have money coming in from any source, lawful, unlawful source, whatever your income source is, you've got to be paying taxes on that money, and you've got to be filing taxes. So if you are a New York City resident, there is no time like the present to be filing your taxes. And so one of the first things you can do to establish that you were working in New York City last year is you go and you file your taxes. You can call 311 and ask for places around town. They're going to be helping people file their taxes for free. So a great way to document the fact that you've been working, as well as comply with the law generally, is to file taxes for all of your income, including off the books. Certainly, if you're making money off the books, that money is probably going somewhere other than under your mattress. You're probably using it to pay your rent. You're using it to buy food. Maybe it's going into a bank account. Maybe you're sending a Western Union receipt. So showing proof that somehow with the money that you're earning off the books is going to also go a long way. But really, right now, through April 15th, you're going to find a lot of providers around town who are going to be helping you file your taxes. It's a separate legal obligation that everyone who earns money has, so that's a great way to document the fact that you've been working here in New York City, if in fact that's the case.
Okay. Great, thanks. All right, so there have been a lot of questions coming in with very specific questions about different criminal convictions, and this is certainly not going to be the place where we're going to be able to address that. Again, it's very important to note that the implications of criminal convictions can be very, very serious, and so to make sure that if you have questions of this nature, that people are going to be referred to places where they're going to be able to get the help they need. That's like places like the Legal Aid Society, and again, that's 212-577-3300. There are actually good questions, general questions, though, about, concerning people with crimes. And one of them is, or a couple of them had to do with people who are currently in custody and whether, if they were otherwise eligible for TPS, would they be able to.
When you say they are in custody, like criminal
custody? Not immigration custody, but criminal custody.
Criminal custody. So it all depends. Again, it goes back to the bars. What they are incarcerated, why they are incarcerated. And so if, for example, the person is incarcerated for a felony or some form of misdemeanor, if, for example, the person only has one misdemeanor, then it's possible that the person may be eligible for TPS, provided it's not a controlled substance, or provided it doesn't come within a crime involving moral turpitude. Okay. I would ask anyone who is incarcerated, who is a Haitian national and thinks he or she might be eligible for TPS, to speak with their criminal defense attorney, who would be able to reach out to someone in any of those legal provider services with that expertise to figure this out for them.
Great. Let's see. Other things were, is the standard that they'll be using to adjudicate the I-601 waivers different when it's a TPS case compared to other applications? Do you know? I'm not sure if that's a...
There's been a lot of talk about what constitutes what is in a public interest, but I believe most people may come under the humanitarian purposes because of the earthquake. But usually, with these waivers, it all depends on what you put on the waiver. I think it will be much more liberal dealing with the TPS issue, because as I said, most people will follow under the humanitarian purposes ground. But if they don't, just being able to show that you can't return home should be a good one. And it could also be discretion based on how many convictions you have or how many of those situations you've been. But once you can show rehabilitation, it happened a long time ago, nothing like this has happened again, it's possible that it would be done. And basically, I think when you're doing an I-601, family ties count a lot. Even if you don't have family, if you can show employment, for example, Julie talked about filing taxes. Those are all things that you can show to indicate that a waiver should be granted.
And just to add to the 601 waiver, the 601 is actually a form, and it's used for people who are making different kinds of legal claims. So there are some times when you need to show hardship to a family member under a particular statute. You would use the 601 form in that situation sometimes. But this is not, the 601 form is also used for different kinds of situations. So in this case, while family ties are certainly very beneficial, as JoJo said, you're going under a different statutory standard. So the form is going to be the same as 601, but the statute relates to humanitarian interest and the public interest. So it's a different statute, though the form is the same.
And so you don't need it. You don't necessarily have to have a particular family member,
Exactly.
like some other 601 waivers.
That's right. So in a
You
different
don't need
context.
a qualifying family member.
Very good.
Okay, I have a couple of questions. One of them is about what happens to someone once they have the TPS. So say there's somebody who only has one misdemeanor and so qualified for TPS, and then is subsequently convicted of a second misdemeanor. Is it possible to lose that, lose the status? And then another question that was sort of related, wasn't with the crimes, but would there be something else that might make them lose it, like if they took some public benefits or something like that? Would that make, would there be consequences after they got the TPS? So I think that's a question maybe for both of you.
So the first question is, someone is granted TPS, has only one misdemeanor. That did not bar him or her from applying for TPS. It's granted. During that 18-month period, he or she picks up another misdemeanor, which would mean she has 2 misdemeanors or more. That would make the person ineligible for renewal of TPS. That is, if TPS is renewed, the person will be ineligible. The person can apply, but it would be denied and referred into immigration court. So that anyone who has a conviction currently, 1 misdemeanor, you are lucky. Don't get yourself into trouble again, because you will not be lucky the next time to be able to get TPS if it's renewed.
And then I want to turn to the public benefits aspect. I think one of the results of the 1996 changes to immigration law is that all immigrants are permanently terrified to get any kind of public benefit at all. And I see that all the time. I work with very poor people, and I encourage and help most of them to get public benefits because they are eligible. There is a specific statute, 212A4 of the Immigration Nationality Act, that prevents people who are likely to become public charges from getting green cards if they're being sponsored by family members or certain other kinds of cases like the diversity lottery or certain employment cases. So there are some situations where if a person who's likely to be a public charge, which is likely to get public benefits in the future, could be denied a green card. But I want to make very clear, a TPS applicant is not covered by that rule. The rule around public charge does not apply to TPS. So if you and your household are living on public benefits now, if you live on public benefits in the future, you are not going to be barred from TPS, not from your initial application, not from any subsequent renewal. Again, I'll just spend a couple seconds emphasizing what public benefits you're going to be eligible for when you apply for TPS. If you, once you get a receipt for TPS, you're going to be eligible under New York State law for the New York State equivalent of Medicaid. So that's usually coming under the Family Health Plus program, one of the Family Health Plus programs. So you'll be eligible for health insurance under New York State. Unfortunately, you're not going to be eligible for New York State or federal cash assistance. So the only change in public benefits eligibility, or really there are 2 if you think of sort of general rules. One, you're going to be able to get health insurance, government-funded health insurance in New York State once you're receipted in. And once the TPS is granted, you're going to be eligible for in-state tuition. So those are the 2 big changes in your ability to get public benefits. But certainly other family members who can get public benefits, they can keep on doing so. It's not a problem. And in fact, proof that many of your family members are receiving public benefits is going to help you in your fee waiver application.
Great. Let's see. I guess this is kind of in a similar vein to some of the other questions, and I guess it would be another discussion that people need to have with their criminal defense attorneys, but what advice should be given to those people who currently have pending criminal actions. So not, when they're still in the process.
So if someone is in criminal court or facing criminal charges currently, that person needs to speak to their criminal defense attorney. Let the criminal defense attorney know that they are Haitian nationals and would be applying for TPS. You need to get a favorable disposition, a disposition that would not hurt you with immigration. So, for example, someone is in criminal court right now, facing charges of controlled substance, possession of controlled substance, in this case marijuana, and they are offering the marijuana violation, 221.05. You don't want to take that violation because it's a controlled substance offense for immigration purposes, would make you ineligible for TPS. You should ask your criminal defense attorney to fight on your behalf for you to get disorderly conduct. That is the only disposition that will help you out. If you are tired of going to court and you are thinking of taking that violation and you've been told that it doesn't have any consequences, don't do it.
I just want to add to that because I have a lot of clients who are not lucky enough to be represented by legal aid attorneys who are absolutely and universally excellent on the overlap of immigration and criminal law. I really want to emphasize to you, if you or a family member is facing a criminal conviction and you don't feel like you're getting super solid immigration pending criminal case, super solid information, you or a family member can really reach out to the resources that are out there. So again, the Immigrant Defense Project hotline, Tuesdays and Thursdays between 1:30 and 4:30, 212-725-6422. And again, we want to correct that number for Legal Aid Society's Immigration Law Unit. That's 212-577-3300.
Okay, I think we have one last question, and this question has to do with a person wrote in that says that they're dealing with a lot of people who express fear and mistrust of the U.S. immigration authorities, and how can we best allay their fears that it would be okay to apply for TPS, and that I guess the fear is that it could later be put into removal proceedings, I guess, when the TPS is canceled. So maybe I'll ask Alan to address that.
Well, we all can have our opinions about this, but my view is that it's unlikely that individuals in any time into the many years forward will be forced to be repatriated to Haiti because of the TPS ends. It's not, the law of course allows for that because TPS has to be renewed every 18 months. But if you think about, for instance, Honduras, which was hit by Hurricane Mitch in the late 90s, those individuals are still allowed to stay here. So what often happens, or what we hope will happen, is that after many years of TPS, individuals either may qualify for permanent residence through another vehicle, or if they're here long enough, hopefully Congress will come through with if the economy picks up, with legislation that would allow these individuals to adjust status to permanent residence. But that's not likely to happen for many years forward. But certainly if it was my family, I would encourage them to go ahead and apply for TPS.